I am an AI avatar created by the law office of Daniel Horowitz to address an issue that the Horowitz office frequently confronts. A nurse or doctor is arrested for a drunk driving offense, and the board wants to suspend his or her license. Can the board do that if the DUI is completely separate from work? This issue was discussed in a 2012 case called Sulla versus Board of Registered Nursing. This published opinion affirms the board's broad authority to discipline nurses for off-duty alcohol-related misconduct, even a single misdemeanor DUI, without needing to prove a direct link to patient care. It sets nursing apart from other professions and stresses public protection over requiring multiple offenses or proof of addiction. Later cases often cite Sulla for the idea that dangerous alcohol use is inherently connected to a nurse's fitness to practice. Here are the background facts. Anuncio L. Sulla, Jr. was a registered nurse with an exemplary professional record and no prior disciplinary history. In August 2009, he attended a party in San Francisco. While driving home to San Jose on Highway 101 in San Mateo County, he crashed his vehicle into the center divider. His blood alcohol concentration was measured at 0.16%, twice the legal limit of 0.08%. It was a single vehicle accident with no injuries to anyone else, and there was no evidence of alcohol dependency or any prior DUI convictions. Sulla pleaded no contest to misdemeanor driving under the influence under Vehicle Code Section 23152, Subdivision B, and received criminal probation. The California Board of Registered Nursing then filed an accusation against him, seeking discipline based on the conviction and the underlying conduct. An administrative law judge held a hearing. The accusation alleged 3 grounds for discipline under the Business and Professions Code. First, conviction of a crime substantially related to nursing qualifications under Sections 490 and 2761 Subdivision F. Second, unprofessional conduct through use of alcoholic beverages to an extent or in a manner dangerous or injurious to himself or to the public under Section 2762 Subdivision C. Third, general unprofessional conduct under Section 2761 Subdivision A. The administrative law judge found no cause for discipline on the first ground, ruling that a single DUI conviction was not substantially related to nursing practice and did not show unfitness. However, the judge did find cause under the second and third grounds based on the dangerous use of alcohol. The board rejected the judge's proposed decision on the substantially related issue, adopted the findings on unprofessional conduct, and imposed discipline. Revocation of Sulla's license stayed, with 3 years of probation that mirrored his criminal probation. Sulla then petitioned the San Francisco Superior Court for a writ of administrative mandamus. The trial court used its independent judgment, granted the writ, and set aside the discipline. The court held that all 3 grounds required a substantial relationship to nursing fitness, which it found was missing here. The board appealed. On appeal, the key issues were these. First, does Business and Professions Code Section 2762 Subdivision C, which covers dangerous use of alcohol, require the conduct or conviction to be substantially related to the qualifications, functions, or duties of a registered nurse? Second, does a single off-duty DUI conviction amount to unprofessional conduct that warrants discipline? Third, an equal protection challenge. Are nurses treated disparately compared to physicians who under a separate statute require 2 alcohol-related misdemeanors before discipline can be imposed? The appellate court reviewed the legal issues de novo, with the facts being undisputed. On the standard of review, trial courts use independent judgment when reviewing professional license discipline, and appellate courts review the trial court's factual findings for substantial evidence, but decide legal questions independently. On the first issue, statutory interpretation of Section 2762 Subdivision C, the statute says, unprofessional conduct includes using alcoholic beverages to an extent or in a manner dangerous or injurious to himself, any other person, or the public. The court held that this provision does not require the conduct to be substantially related to nursing practice. Unlike other sections that explicitly use the substantially related standard, this one contains no such language. The legislature deliberately omitted it because alcohol misuse poses inherent risks in nursing, such as impaired judgment that could affect patient safety. There is a logical connection between alcohol-related misconduct and nursing fitness, even when the conduct is off-duty. The trial court erred by reading the substantially related requirement into this section. On the second issue, application to a single DUI, the court ruled that a single instance of dangerous alcohol use, like driving with a blood alcohol level of 0.16% and causing an accident, qualifies as unprofessional conduct under this statute. Nurses hold positions of public trust, and impaired driving shows poor judgment that could carry over to risks in patient care. The board did not abuse its discretion by imposing a stayed revocation with probation. This was a lenient outcome with no actual suspension, and it was appropriate given the mitigating factors: an excellent work history, remorse, and no evidence of substance abuse issues. On the third issue, equal protection, the court rejected Sulla's argument. Nurses and physicians are not similarly situated because of differences in training, roles, and supervision. There is a rational basis for stricter oversight of nurses on alcohol issues, since nurses frequently administer medications and monitor patients without direct physician oversight. In the end, the judgment of the Superior Court was reversed, and the board's disciplinary order of 3 years probation with stayed revocation was reinstated. The California Supreme Court denied review in August 2012, making the appellate decision final. The bottom line is that while the lawyers raised excellent legal issues, alcohol use and abuse are considered substantially related to the practice of nursing, and nurses can and are disciplined when these offenses come to the attention of the board. I am an AI avatar created by the law office of Daniel Horowitz to address an issue that the Horowitz office frequently confronts. A nurse or doctor is arrested for a drunk driving offense, and the board wants to suspend his or her license. Can the board do that if the DUI is completely separate from work? This issue was discussed in a 2012 case called Sulla versus Board of Registered Nursing.
The law office of Daniel Horowitz specializes in the defense of nurses and doctors in criminal defense cases. If you're facing criminal charges and are concerned about the fairness of your trial, we can help ensure your rights are protected. We have experienced legal professionals on staff who are committed to handling every aspect of your case with care and attention to detail. Call us today at 925-283-1863. Again, our number is 925-283-1863.